from tenants isn't black and white.
If it doesn't say it in that letter, then it's not in that letter.
It doesn't say that in the letter.
Okay.
And a landlord learns there's no gray area.
It has to be in written form, just like this letter.
Well, you got me there, Judge.
You snookered him.
This is Judge Judy. Jonathan and Sarah Santibanez are suing their former landlord, Dave Schaefer, for the return of rent and their security deposit.
Judge's case number 125 on the calendar in the matter of Santibanez versus Schaefer. Parties have been sworn in. Sir, have a seat, please.
Mr. and Mrs. Santibanez, you rented a house with your family of 8 people from the defendant since 2014, so a little over 6 years. And according to your statement, in the end of July of this year, Mr. Schaefer advised you that he wanted you out of the house by October the 1st, and at all times you have been current in your rent. I think that all the parties will agree with that. Yes. Correct, Mr. Schaefer?
Yes.
What was the address of the house that you rented from Mr. Schaefer?
The address was 1750 in Oceanside.
Mr. Schaefer, when did you purchase before they rented it? So in approximately 2012.
Yeah.
How much did you pay for it?
I think it was $470,000.
Did you ever live there?
Well, I was working on it, yeah. I do my own work, so I lived there on and off for the full 2 years.
So you bought it as a fixer-upper, and you lived there while you made it ready to use as a rental property.
Yeah, well, we wanted to sell
me?
it. We wanted to sell it, but that didn't work out.
Well, after you fixed it up, you tried to sell it, and that was in 2012. Is that what you're telling me?
Okay, yeah.
Couldn't sell it, so you decided to rent it.
Yes.
And they paid rent. Their rent was $3,200 a month.
I think at the beginning it was a little less.
But now, the last year or two or more, it was $3,200 a month. What was it initially?
Initially, it was, wasn't it $3,000?
Initially, it was $2,850, and then it progressively went up.
Okay, but your rent when you left was $3,250.
Correct.
And you did, in fact, leave by October 1st.
Yes.
Correct?
Correct.
Do you still, Mr. Schaefer, own 1750?
Yes.
Is it currently on the market for sale?
Yes.
That is not an answer, Mr. Schaefer. Is it an escrow?
It's for sale.
Do you currently have it on the market for sale?
Yes, it is currently.
There's no MLS.
Would you?
Okay.
I'm going to.
Thank you.
What is it on the market for sale? At what price?
We
Mr.
didn't
Schaefer?
have a price. The real estate agent is here with me as a witness, and we never settled on a price. We have to do a little work on it first, and then it'll probably be around $1 million.
Who is living in the house now?
Nobody's living in it now.
Okay. They moved out on October 1st. What work have you done in the house?
Well, since then, we tried to get the little stream running on the front. We've added a couple of closets in bedrooms so that they would actually be called bedrooms, because you have to have a closet in them to be calling a bedroom. Some patching work on one main wall in the main house, and we turned one of the little garage rooms below into another bedroom, and we had to make that...
So you've renovated the house in order to double what you paid for it.
That would double what we paid for it. Not what we had in it, but double what we paid for it, yes.
Double what you paid for it.
Yes.
And during the past 6 years or so, you've had a tenant who's faithfully paid you on average of $3,000 a month for the house. Now, this is what the situation is. You made a deal with the plaintiffs, Mr. Schaefer, and your deal with them was that if they left the house in good condition, not only would they get their the realtor, who is your witness, you would return their September's rent, which was $3,250. When they moved out, you not only didn't give them their September's rent back, but you deducted money from their security deposit. So this lawsuit is about the deal that you had with them, that you would pay them sort of a bonus to get out by October 1st.
Exactly.
And this is during a COVID moratorium on evictions, you understand, in the state of California. So you would give them a bonus if they moved out on October 1st and return their security. Your answer suggests that, well, they did a little bit of damage, so you deducted $800 for their security, and they didn't fully cooperate with the realtor.
They didn't cooperate at all, and that's what he's here to go along with.
Great. So they didn't cooperate at all.
Not at all.
So those are basically the facts. Do I get that right, sir?
Yes, in a sense.
Well, what sense is wrong?
I do have the notice to terminate the lease, where it does say nothing about cooperating with a realtor, if you'd like to see it.
I would. The letter that he sent you that you agreed to.
For the termination.
Giving you a 6-day written non-renewal notice, letting you know that I will not be renewing your month-to-month lease. I am giving you a required 60 days notice via this letter. However, in the interest of it, I would extend the 60 days to October 1st, which means that you can stay on property until October 1st, which should make a move easier for you and your family. Lastly, if the property is turned over on October 1st, which he realizes that you didn't have to do, in good and clean condition, I will refund your September's rent in addition to your deposit. Feel free to call me if you have any questions. Do you recognize that document, sir? And is that your signature? I'm checking it with the signature on your answer.
Yeah.
That's the letter that you sent to them.
I don't remember all of that.
Okay, point out any place in that letter where it says that he has to cooperate with your realtor.
If it doesn't say it in that letter, then it's not in that letter.
It doesn't say that in the letter, Mr. Sheindlin.
Okay. Then it must have been in the conversation we had immediately after the letter. Immediately.
Let me explain a little bit about contract law to you, sir. You made him an offer in this letter. It's a written offer. He acted on this written offer by moving out on October 1st. So the contract is complete. The only act is by a writing, not a conversation, not a telephone call, not a chat before, not a chat after. It has to be in written form, just like this letter.
Well, you got me there, Judge.
And quite frankly, of course, Mr. Schaefer, you know, you actually do understand that not only do you have this letter, but by your own statement, sir, it didn't matter whether he cooperated with your realtor or not, because you haven't put the house up on the market for sale. And the reason you didn't put the house up on the market for sale is because you said you were doing work on it to make it more attractive. You added a bedroom. You made closets so that you could say it's a 6-bedroom house or a 5-bedroom house or a 8-bedroom house instead of what it was in order to comply with code. So you haven't even listed it for sale. So that if you said to me, well, I listed it for sale, and we discussed that given COVID, I would give him notice and I would keep the showing short, you haven't even listed it according to you. So how you actually dare to say that your defense is that he didn't cooperate with a broker when he's been out of the house for 2 months and you haven't even listed it yet? That's what you just told me a moment ago.
He was supposed to cooperate.
Other than the fact that you snookered him. Yeah, go ahead.
Judge Judy continues in a moment.
What is this useless broker here? He has nothing else to do with his time than go and look at your property?
That's right. And he was supposed to allow the...
Then you have an idiot for a broker, and so are you.
Jonathan and Sarah Santibanez are accusing their former landlord, Dave Schaefer, of reneging on an agreement to return their rent and security deposit.
Now, you haven't even listed it according to you. So how you actually dare to say that your defense is that he didn't cooperate with a broker when he's been out of the house for 2 months and you haven't even listed it yet? That's what you just told me a moment ago. So how was he supposed to cooperate with your broker?
He was supposed to cooperate.
Other than the fact that you snookered him. Yeah, go ahead. Go ahead.
He was supposed to cooperate, fully cooperate, and I remember talking...
What was he supposed to... No. Schaefer.
Yeah.
What act was he supposed to do to cooperate with your broker?
He was supposed to allow the broker to look at it whenever the broker wanted to. He was supposed to allow... So the broker would see it.
For what? To look at it because he had nothing else to do but look at your house? It wasn't listed for sale and hasn't been listed for 2 months. He moved out October 1st. All of October and all of November, you haven't listed it. What is this useless broker here? He has nothing else to do with his time than go and look at your property?
That's right. And he was supposed to allow the...
Then you have an idiot for a broker, and so are you. You own $4,000 $50. Judgment for the plaintiff. We're
Okay.
done. Thank you very much.
Thank you.
Case is concluded. Parties are excused.
Well, I always heard she was going to tear me apart, and she did.
I'm very pleased with her decision. We are good tenants. We paid our rent on time every month.
These very nice people did not cooperate with the broker in allowing him to go see it.
We were shocked when he would not refund what he said he would give us, which is his word in writing.
When he called quite often, 4 or 5 times, they didn't even answer his calls.
I mean, and especially during COVID-19 when you don't want people in your home.
He was supposed to let the brokers see it.
You don't want to be outside the home. You don't want to be showing the home.
They did not show them any cooperation, not only not full cooperation, not any cooperation.
I think it was a good ruling on Judge Judy's part.
All parties in the matter of Foley versus Mounier. Step to the podium, please.
21-year-old Emily Foley is suing her Mounier for failing to return her portion of a security deposit for an apartment they never moved into.
Miss Foley, you and the defendant were friends for a long time and recently decided to rent an apartment together. You located an apartment, and I was unclear, did both of you sign the lease or just the defendant?
Both of us.
And you were supposed to move into this apartment on...
September 5th was our move-in date.
Okay. In order to accommodate that, you gave the defendant $1,400, and you transferred that into her bank account. Do you have proof of that?
Yes, I do.
Would you please take it out?
This is the total that I gave her. The $300 and the $1,000 was towards the deposit on the apartment, and the $145 was $100 for a $200 holding fee and $45 for a credit check fee. And the $50 was a personal loan that...
Just a second.
Okay.
A credit check fee.
Yes, for the...
Is that what you're telling me?
Yes.
Okay. I got it. At some point, the apartment complex that you were leasing from notified you that the apartment would not be ready on the move-in date that you were given in the lease, and the apartment complex gave you you decided that you wanted to back out of the lease.
Yes.
You no longer wanted to go forward with it. And what you are suing for is the return of the money that you sent to the defendant, because the defendant seems to acknowledge that she received that money back from the apartment complex. Am I correct?
I didn't receive everything back. I did receive a portion of it.
How much did you receive back that you can prove to me?
The only thing I didn't get back was the holding fee and both credit check fees.
And I would assume that you wouldn't have gotten the credit check fee.
Yeah. They told us we
Back.
weren't going to get that back.
What was
and then
that,
we didn't get
40?
It was
Right.
$45 per
Right.
person.
Okay. So they did, in fact, return to you most of the deposit that the plaintiff gave you.
Yes.
You said you would return to her only $400 of the deposit, and your reason was that you purchased things, I assume, for the apartment.
Yes.
In contemplation of moving into the apartment together. She was the one that didn't want to go forward with it if you had to wait 2 weeks, and you got stuck with stuff that you would not have otherwise purchased. Like what?
A kitchen table, and then I did the renter's insurance.
Just a second. Where is the kitchen table and chairs?
I had to end up getting a new one because that one was too big, and I had to move. I was already...
Table and chairs.
Yes.
Was it delivered?
No, I stopped the delivery.
You stopped the delivery.
Yes, I couldn't get my money back. They said I could either keep that one or get one that was smaller.
Prove it to me.
Judge Judy continues in a moment.
You bought another one.
Yes, because that one was too big, and I was forced to keep that and keep buying stuff from them.
Okay, listen. I mean, I may be older than you are, but I know young people think they're smarter. I want you to give me a full sentence answer.
Real cases, real people. Judge Judy. 21-year-old Emily Foley is suing her former friend and roommate, 24-year-old Amber Mounier, for failing to return her portion of a security deposit for an apartment they never moved into.
You bought a kitchen table and chairs.
Yes.
Was it delivered?
No, I stopped the delivery.
You stopped the delivery.
Yes, I couldn't get my money back. They said I could either keep that one or get one that was smaller.
Prove it to me.
It says on the very bottom how you can't get your money back.
I see what this is, and I see what you signed, $450 that you paid. Did you buy another one?
I paid $100 more.
Did you buy? The question is, did you buy another?
I was forced to keep that and keep buying stuff from them because I was going to lose out on all that money.
Okay, listen. I mean, I may be older than you are, but I know young people think they're smarter. I want you to give me a full sentence answer. The answer is you took this $450, you added another $100 to it, and you bought another table that you currently own.
Yes.
Isn't that simple? Look how I said that. Without convoluted, without anything. Did you move into another apartment?
Yes, I did.
And you now have a kitchen table and chairs, right?
Yes.
That cost you $550, that you own it.
Yes.
Good. What else did you buy?
The renter's insurance.
Renter's insurance.
Yeah, we have to have renter's insurance in order to move in before we could even move in.
Fine. You ordered the renter's insurance, but before the renter's insurance went into effect, you canceled it because you never moved in.
No, we did not move in.
You never moved in. So if you never moved in, there shouldn't be any insurance. You were uncovered because you didn't own or rent the property. Are you telling me you had a loss with insurance that you're going to have to prove?
No, I didn't say that.
You didn't say what?
That I had a loss of insurance.
Well, you just told me. I said, well, did you pay for that you didn't use?
I did pay for it.
You said
it took
renter's
8 weeks
insurance.
to get the money back.
Trying to figure out what you spent money on. So far, it's nothing. So she's entitled to her $1,400 back, or $1,300.
First of all, I got several text messages from her mother saying that it was $1,200. She posted on Facebook $1,500, and then it was $1,691.
I just want to know how much. You just showed me what you received from her.
This is what I received. I have my bank statements. Because when it transfers, it doesn't go directly. It, takes money out of it when you transfer it to your account from Cash App.
She showed me what she sent to you. Are you disputing what she sent to you?
Yes.
What specifically are you disputing? The $1,000?
No.
Are you disputing the $300? What are you disputing?
Judge Judy continues in a moment. Closed captioning sponsored by. Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
She showed me what she sent to you. Are you disputing what she sent to you?
Yes.
What specifically are you disputing? The $1,000?
No.
Are you disputing the $300? What are you disputing?
So, Your Honor, when it gets sent through Cash App, when it gets transferred to your bank account, it takes a portion of it out. So I didn't get that full amount.
What? Just what portion?
It ended up being...
Just what portion? If it was $1,000, how much did you receive?
$990.
$990?
Yes.
Okay, that's $10. Okay. And how much of the $300 did you receive?
It was $990, and then I received $297.
Did she return $400 to you?
She returned nothing to me, Your Honor. And if I may, Cash App takes a percentage out when you choose to instantly have it. It takes 2 to 3 business days, but it's a choice to, that percentage that they take out. You can choose to have them not, and you can get the full amount that I sent her. That was her choice to have it instantly. It was not.
$1,350, judgment for the plaintiff. We're finished. Thank you very much. We're done.
This case is concluded. Parties are excused.
And on the next Judge Judy.
It was just so awful. I just couldn't take it anymore because he was cursing at me and yelling at me.
That, sir, is not a demonstration of someone who's in fear.
Judge Judy.
I believe it was the right decision. I put money towards an apartment. We didn't get the apartment. I got my money back.
I don't mind her decision. I don't owe her anything. I don't really care.
Honestly, I was glad that the apartment wasn't ready in time because her true colors came out before that.
This happened that's fine.
A lot of lies came out, and I was, having second thoughts already.
They offered us that we could even get a different apartment, that we could move in that day, and she didn't want to do that. She wanted that specific apartment.
When the opportunity presented itself, I took it. I did what was best for me and my child.
I will always love her son. That's my godson.
She's not actually the godmother to my child. She kind of just took on that role.
I don't deal with like this.
I'm ready for better things, and I wish her peace and happiness in life.
After a death in the family, a tug of war.
Your mother signed a document that you should have the car.
That's correct.
What your sister did was pull a fast one.
Now sisters collide head on.
I'm trying to get what's going on here. You came in and you paid off the car.
They said it was going to go into default.
The car wasn't in default.
I didn't know that.
I think you played it cute.
This is Judge Judy. Christine Espinosa is suing her sister, Sandra Espinosa, for the return of a vehicle she claims belongs to her.
Judge, this is case number 133 on the calendar in the matter of Espinosa versus Espinosa. Parties have been sworn in.
Espinosa, the defendant is your sister, and each of you claim that they own a car that had belonged to your deceased mother. That's what this case is about?
Yes.
So I have a few questions. First, who has title to the car in their possession?
I do.
What state do you live in, Miss Espinosa?
Utah,
And in what state did your mother live before she passed away in May of this year?
California,
And in what state did your sister live in May of this year?
California,
At what address did your sister live in February of 2020?
I believe she was with my mother in Marietta.
Yes, she did. She lived with your mother.
Yes.
How long did she live with your mother?
Let us say a year, that I recall.
Was your mother sick during that year?
Yes.
What was the nature of her illness?
She had age problems and
Miss Espinosa, what was wrong with your mother?
She had dementia, spinal stenosis, diverticulitis, heart issues.
Where had you lived before you moved in with your mother?
I was actually in Las Vegas.
Did you work?
No, ma'am. I was out on a job injury,
What was the nature of the job injury?
a back injury.
Okay, so that's what was wrong. Your mother had dementia. She had spinal stenosis. That's why your sister was there, at least in part. How many times in that year that your sister was there did you visit with your mother from Utah? Any period of time?
at least a weekend.
And so it's your testimony that you were there almost monthly.
I tried to, yes.
If I were to ask your sister and the other people who were here as witnesses, would they say you were there almost monthly to see your mother?
Probably not.
How many times do you think that they would say you visited your mother in that year?
Maybe 5.
Maybe 5. Would that be a closer figure to how many times you visited your mother in that year? Close to 5?
No, I say 8, about 8 times.
Now, your mother had a 2013 Kia. Your mother died in May. Prior to your mother's death, did you purchase that car from your mother?
No.
In what month did you contact the finance company to see how much was left on the loan?
That would be in August.
When you contacted the finance company, can you tell me the reason you contacted the finance company?
To purchase the car, because they said it was going to go into default.
How would you know that? You had never been involved with the car prior to your mother's death.
Right.
You weren't on the loan.
No, I wasn't.
So what prompted you to call the finance company?
I didn't want them to repossess the car.
Listen to me. You were never involved with this car. What would have prompted you to call the finance company? I don't know. You weren't on the loan. So you contacted them.
Right. I just needed a car. It was a good car. I did not want it to go back to the bank. I wanted to keep it in the
Just
family.
a minute. So you called to see if someone else was making the payments. Because if they weren't making the payments, you could hop in, pay the car off, and get it.
Yes.
I mean, that has to be the answer. You called to see if someone else was making the payments. And what I want to know is, in what month did you call them?
The beginning of August.
Well, you wrote to Motor Vehicles in August. Show me the check or the proof that you paid off the car. I want to see what date it was.
Here's the wire transfer to the bank.
That was in July.
Is that July?
That was in July, not August.
Oh, I'm sorry. I have my wrong dates. I apologize.
And what date did your mother pass in May?
May 7th of 2020.
So the beginning of May.
Yes, ma'am.
Before your mother passed away, who made the car payments on this car?
My mother was making them up until about April when I got a phone call from the loan company. It was a wellness check due to the COVID. At the end of the conversation, the representative asked me if everything was fine, and I said yes, but she repeated the question again. I go, yes. She goes, well, just to let you know, you're 1 payment behind, and in 4 days, you'll be 2 payments behind. The other sister that lives in Florida was in charge of to be made. I did ask my mother if she was aware that they had stopped making the payments on there, and she said no.
Just a second. Did you ever make the payments on the car?
I started making them after they told me that there was 2 payments behind. So the first payment that I made was for the sum of $800 in May.
So can you show me proof that you made the payment in May?
Yes, ma'am.
So that made up for April and May. Ms. Espinosa, did you make another payment in June?
Yes, I did.
Do you have proof of that?
I did have it because I did make the payment.
How much was that payment in June?
The payment was, I believe, $387, but my mom always made $400 payments, so I was making $400 payments.
Okay, and then you came in and you paid off the car.
Correct.
So the car wasn't in default. She had made payments on the car. One sister had, and then she made payments up for April and May and June.
I didn't know that.
Well, why didn't you ask?
They told me it was in default already.
No, I don't believe that. Unless you have a letter from them that it was in default, she has proof she made the payments. It wouldn't have been in default.
I don't have a letter.
I think you played it cute. I think you had a paid-off car, and all it was going to cost you was $30. Going to help you? That's unlikely. Miss Espinosa, you have physical custody of this car. Is that correct?
Yes, ma'am.
Your sister paid off the balance of the car.
I found out via letter, yes.
This court doesn't think she should have the car because what she did was pull a fast one. And you're going to tell me that your mother signed a document that you should have the car.
That's correct.
In what month and year?
The letter was written on October 30th of 2019, and it was notarized on May 2nd of 2019.
Well, you see, my problem is, Miss Espinosa, that you testified a moment ago that your mother suffered from dementia.
Yes, ma'am. She was in the early stages of dementia.
And that, well, that's not what you said before.
No, it is not what I said.
And you said that your sister in Florida was taking care of paying for the Kia, which I assume you were driving.
Yes, ma'am.
Okay, so I actually think that your sister did not do the right thing by coming in and calling the finance company. They're more than happy to have somebody pay off the car and not have to deal with it anymore. So they said, fine, she'll pay off the car and we'll give her title to the car. Did your mother leave any other property other than this car?
She had her personal belongings also. There was a lot of undermining with that also.
But she didn't leave a house or any...
The account was under my sister's name in Florida. She ended up with that also. Whatever my mom had in the account at that time.
This sister or the sister in Florida?
The one in Florida.
Ended up with that bank account. So they had a joint bank account.
Yes, it was originally under my name with my mother's.
And was your mother receiving Social Security?
Yes.
So your mother's Social Security check was going into that joint bank account?
That's correct.
And your sister was paying the car note from that bank check?
To my knowledge,
right?
Yes.
And how many sisters are there?
There's 5 sisters and 2 brothers.
Oh, big family.
Yes, ma'am.
Does anybody else want this 2013 Kia?
I honestly don't know because I wasn't even aware that this was happening until I called the bank after I received the letter indicating that my other sister in Florida was the owner of the car and they had paid the vehicle off. I did call the bank and I asked them how that happened.
Just a second. The car was in your mother's name and your other sister in Florida?
No, that's the document that I received after the fact.
But was the car in your
my mother's
name
solely?
And solely?
Yes.
Now, you don't have a counterclaim.
Well,
at least for the money that... Yeah, go ahead.
I was just going to say, I just found out about all this shenanigans just about a week and a half ago, 2 weeks ago, if that at all. I wasn't aware. When I called the loan company, I asked them what was going on, and they said that my sister in Florida had... So they sent her the documents so that she can sign up, and that's how they understood it.
Hold on a second. Are you in touch with your sister in Florida?
Yes.
Miss Espinosa?
Yes, I am.
You are? Oh, that makes it easier for me. When I say you're in touch with your sister in Florida, are you in touch with your sister in Florida about this car?
We were, but I talked to her every day besides the car situation.
Well, she was the one that was handling this. Who paid off the car, you or your sister in Florida?
I paid the car off.
Just look at me. Shh. With whose money?
My own money.
Did your sister send you any money?
No, she did not.
Was there any money in the joint bank account that your sister had with your mother?
I don't know that financial.
That's a yes or a no. Yes, you do. Yes, you do. You know because you speak to your sister every day. How much money was in the joint bank account that your sister had with your mother?
I don't know because I don't handle the financial stuff.
Well, then I'm going to ask your other sister. She's going to give me an answer. And so if you don't know, I'm going to believe her answer. Do you understand that?
Yes.
How much money was in the joint bank account? Do you know?
All I can do is estimate that there was approximately $8,000 in there, and then the stimulus check was added on there on April 29th of this year.
And do you know how much money your mother received from Social Security every month?
To be honest with you, no.
Was your mother a working person?
Retired for a few years already at that time, but she was also receiving compensation from my father's retirement also.
And do you know how much she was receiving?
No, ma'am.
I'm going to repeat myself. Did your sister send you any money from your mother's joint bank account?
She did not, Your Honor.
Did you ask her about it?
No, I did not.
I don't believe that.
Tell her why she started paying. Can I please say something?
Yeah, now I'll hear you have a witness?
Yes,
Sure. Come on up.
Judge Judy continues in a moment.
Miss Espinosa.
Yes, ma'am.
I'm going to take a look at these bills while you had control over your mother's finances. So I'm going to ask you, did you ever use any of that money at casinos?
Christine Espinosa claims her sister, Sandra Espinosa, is in possession of a vehicle that belongs to her.
Yeah, now I'll hear you have a witness?
Yes.
Sure. Come on up.
Hi, my name is
Who
Michelle
are you?
Espinosa. I am the sister-in-law. I am married to their brother.
What
so
I
the
wanna know-
reason
what I want to-
that the sister in
Don't-
Florida started taking over the payments was because we found discrepancies and withdrawals in the statements that Sandy was taking money out near gambling places, $300 at that time. I have the statements here on credit cards that were in Georgia's
That's from-
name only. In the time frame
That
that we're
were in-
discussing, from
Just a second.
August to February.
Okay. So what you're saying is that the defendant had control over some aspect of your mother's finances, and that was changed.
Correct, because of the evidence that
So
we
your
found.
sister in Florida.
Exactly, because there was
Okay.
something that was not adding up.
How much was not adding up?
I have it
much?
here
Look
in
at
the thousands. I have it all highlighted on the money that she took out in different places. I would say at least
And
$3,000.
this was from...
Of the statements that we have. We don't have all of the statements. And she was paying her phone bill out of it, and she was paying her psychics, like all sorts of different things out of her mom's.
Okay. Did you have discussions with the defendant in front of your mother?
Yes, my stepson did, and his
No,
mom.
I want to know if you did.
If I did not, in
I
front
wanna
of
know
her,
if you
no.
would-
I had
no,
a discussion
no,
with Georgia regarding the theft, but I did not have a discussion with Sandy when I was there taking care of her at
Not
one time.
interested. Not interested. Not interested. Miss Espinosa,
Yes, ma'am.
I'm going to take a look at these bills while you had control over your mother's finances. So I'm going to ask you,
Yes.
did you ever use some of your mother's money? Did you ever use any of that money at casinos or to pay a phone bill of yours?
Yes.
Yes,
that is true.
because-
My mother was aware of it because I asked her if I can use her credit card, and she was aware of it.
Oh, no. No, that I don't believe.
Okay,
No,
no,
that
no.
I don't believe.
No, it is the truth. I don't know if you believe me or not, but the withdrawals were withdrawals that I did for my mother, and I asked her on several occasions because she asked me if she could take money out of it, because I asked her to take the money out of one of them to consolidate all her credit cards. And then she finally asked me for the cash. She says,
Okay.
Mom, do you need it? She says, no. I says, and why do you want me to take it out? She says, because it's my money. That was her answer.
Okay. Yeah. Okay. Your mother didn't go to a casino, did she?
No. I went over that way, and I
No.
told her I was going to withdraw from her.
All right. Okay. Yeah. Okay. I'm trying to get what's going on here. Now I'm going to hear from... Pick which witness you want me to hear from.
Probably Karen.
Miss Espinosa.
Miss Karen Wilson. She's a good friend of my mom.
Okay.
She's known her for over 30 years.
Okay, great.
Judge Judy continues in a moment.
Is it your intention to sign title over to her?
I'd like to take the car home with me.
Well, you don't have the car. And I know that you would prefer to have the car because it's a good little car. But I actually think that you were a Swiftie.
Real cases, real people. Judge Judy. Christine Espinosa is accusing her sister, Sandra Espinosa, of withholding a vehicle she has the title for.
Miss Wilson, you were a friend of Miss Espinosa's mother for how long?
Probably about 30 years.
Did you see her in the last year of her life?
Yes, I did.
Who was her primary caregiver the last year of her life?
Sandra was.
How many times did the plaintiff come to visit in the last year of her life?
I had never seen her there before. This is the first time I've met her or I've seen her. But from what Sandy told me, when she came, it wasn't.
No,
that...
don't tell me what.
Okay.
Okay. Don't tell me what Sandy told you. You never saw her.
I never saw her.
Was her last name Espinosa? Your friend.
Well, I knew her as Georgia.
How often did you see her?
Probably about once a week.
Did you ever have discussions with Georgia about who she wanted to retain this car.
Yes, I did. Back in 2018, Georgia was concerned that once she passed, it was going to be a big fight with her family. And it upset her. She was concerned about it. And I told her, I said, you know, the way you can get around that is just make a list and who you wanted to go to whom. And so she had discussed with me, you know, she wanted Sandy to have the car for taking care of her because she did such a good job. And she did. When I went over there, the house was always clean. Georgia was always fed. And, you know, she was doing good.
Well, so this is my question to you. Somebody paid off the car. Somebody was going to have to pay off the car. You know, make regular and consistent payments on the car. Otherwise, it was going to be repossessed. The plaintiff, although I think her motives were not born out of goodwill, and certainly the timing was not consistent with being a relevant sister, she did pay off the car. Your friend has been driving the car for about how long? 6 months? 8 months?
Actually, the car...
6 months.
The car's been sitting for about 2.5 months when all this started.
It may have been sitting, but prior to that, you drove it.
Not frequently, but yes.
You drove it in May, you drove it in June, you drove it in July, you drove it in August, you drove it in September. Then this all started, May, June, July, August, September. You drove the car for 5 months, and you paid $1,200. That's the only money that you say you paid towards the car.
Yes, I was making the monthly payments on there. The day after my mother passed...
You made $1,200 worth of payments towards the car.
Judge Judy continues in a moment. Closed captioning sponsored by... Are you in a family dispute? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay, now, the only thing that you paid towards that car was $1,200, and you drove that car May, June, July, August, and September for 5 months. That's all I'm saying to you. That's either a yes or a no.
Yes.
And your lawsuit, actually, you're asking for $3,700, which is what you paid when you paid off the car, because your sister actually has physical possession of the car. Yeah. Now, is it your intention to sign title over to her?
I'd like to take the car home with me.
Well, you don't have the car. And I know that you would prefer to have the car because it's a good little car. But I actually think that you were a Swiftie. So I don't think I'm going to make that judgment, but I am going to award you what you paid for the car, which is $3,700. Judgment for the plaintiff. Thank you. In order to get that, we will hold up the check. When, in fact, you sign over title to the car, you get your check. Do you understand?
Yes.
Otherwise, you get nothing.
Got it.
Perfect. We're done. Thank you.
This case is concluded. Parties are excused.
And on the next Judge Judy.
Just vendetta. That's all it is. Just bad blood, what have you.
I don't believe it was a vendetta.
They were all there just a couple days after my mom passed, and you have to get out of the house.
I wanted the car because it belonged to my mom. It meant a lot to me.
You have to get out of the house. When? Now.
I don't believe she deserved it.
I mean, electricity was turned off and everything else. Yeah, it's all wrongdoing.
She's stealing from my mom and taking advantage of her.
They came in. You have to get out. That was my window there.
We found statements. Her withdrawals on there.
Just hurry.
We stopped all the cards and everything.
Because I knew what my mom requested and I knew what her wishes were.
Everything's about money, her.
I don't even care if I even see them anymore.
She's very sad that it came to this.
There's been so much wrongdoing to her.
I hope best for them.
Did you have the leash in your hand at all times?
Yes, I did.
A neighbor says she has no grip on reality.
The pit bull had broken away from the owner. The dog was totally clenched onto my dog. I was screaming. She got the dog off of my dog.
Will she ever let go of her story?
Exactly sure how he got the leash out of my hand.
I'm not sure either.
This is Judge Judy. Donna Cullum is suing Nicole Anderson for vet bills and medical bills after she and her dog were attacked by Nicole's pit bull.
Judge, this is case number 141 on the calendar in the matter of Cullum versus Anderson. Parties have been sworn in. You may be seated, gentlemen.
Miss Cullen, you have 2 terrier dogs.
Yes.
Do you have photographs of them?
I do.
May I see them, please? They look as if they weigh about 12, 14 pounds.
20, 22 pounds.
They like to eat.
Mm-hmm. They're both pretty healthy.
How long have you had them?
The one on the left, which is Hannah, is 10. I've had her 5 years. And the other one is Sasha. I've had her 13 years.
And this is, I assume, your boyfriend that you were with that day?
Yes.
And you have a pit bull.
Yes, I do.
Miss Anderson, how old is that dog?
He was about 10 years old, almost 10.
How long have you had him?
I've had him since he was 8 weeks old.
And what kind of a dog does your boyfriend have?
He has a basset hound.
Do you live together?
Yes.
And how old is the basset hound?
He's 1 year old. Yes, they're always together.
This incident happened between not only the two of you, but your two dogs on October 12th of this year. Do you want to tell me what happened, Miss Cullum?
Yes, about a little after 7 in the morning, I was walking my two dogs. I was about a block from my home, and I looked down to the right on the next street, and the defendant and the gentleman were walking two dogs towards me.
They were on the same side of the street?
They were the side. Can I show it on the...
They were together?
They were together.
They were together?
They were together. But they were across the street.
But on the
opposite side of the street, down the end, towards the end of the street. And I was walking forward.
So they were on the opposite side of the street from you?
Yes.
Okay. And then what happened?
I got to about where the street was, and I was crossing, and I looked, and I saw that the pit bull was getting a little aggressive, and I decided, well, I couldn't turn around and go back because they were coming the direction of my home, so I decided to go ahead.
Would you point to where you are and where the defendant is? Are you in blue or are you orange?
I'm orange.
You're orange. Okay, great. So you were walking down the street.
I was right here.
So this incident happened in the middle of the street?
Yes.
Okay. Now, Miss Anderson,
yes.
I want you to look at Miss Cullum's evidence to say that that's where the incident took place between the dogs and you.
No.
Show me where you think the incident took place.
And so, if I'm the one in the blue, we were actually on the same side of the street when it started to happen right here.
So you were on the same side now of the street with her.
Over. Yeah, we had crossed over.
Just a second. Okay, so my question to you is, you had crossed over to the same side of the street that she was walking on, and you were walking up that street. Is that what you're saying to me?
That is correct.
That, Miss Anderson, that you were walking up the street where she was walking her two little dogs?
Yes, because we lived on that same street.
Okay, show me where you live.
Okay, so she lives
Show me.
We're going up the street. You turn right here on Treviso Avenue. That's
Yes.
our house in that cul-de-sac.
So your house is in that cul-de-sac. So you didn't necessarily have to be on the same side of the street that she was. You could have been on the other side of the street and crossed at the next corner. I'm just looking at your photograph.
Yeah, we were crossing to go home.
If you're the blue dog, you could have stayed on without crossing over. You could have walked up cul-de-sac where you live. Am I correct?
You're correct.
So I assume that when you saw her with her two dogs, you had to have seen her because you crossed over, and according to what you say, you weren't very far away from her.
Yes.
So you had to have seen that she was there with two dogs.
Yes.
Okay, go ahead, Miss Cullum.
I was crossing the street, and I saw that the dog, the pit bull, had broken away from the owner and charged, as that black shadow shows, and came and got to my dog.
Okay, when you say broke away, Miss Cullum, from the owner, the defendant's dog was on a leash, had been on a leash along with the beagle, or basset hound.
Right.
Basset hound. They had both been leashed. According to what I've read here, when you say got away from, break away from, so the dog was no longer attached to the defendant?
Exactly.
Or was she? So at the time this happened, the defendant was no longer holding on to the leash?
Yes.
Is that what you're telling me?
Yes.
Go ahead.
By the time I saw the dog, I couldn't get away. And it came and it grabbed Hannah, and I went to grab him as much as I could. Hannah came around and out of defense at the top and bottom of my left wrist. I curled up into a ball and ended up on the ground, and I was screaming. And the next thing I knew, Doyle, with the defendant, came running around, and he somehow
You
got...
mean the man?
The man. He got
He
the
came
dog.
around.
I didn't see it. He got the dog off of my dog. The dog was totally clenched onto my dog.
Did you see how he did that? Did you hear him say something?
No, I didn't see him do it. My husband, he told my husband how he did it.
Were you present when he told your husband how he did it?
I was there, but I didn't hear it. I was on the ground.
Is your husband here?
Yes, he is.
Would he come up, please? Your last name is same, Cullen?
Yes,
Mr. Cullen, you were not with your wife at the time, is that right?
that is correct.
Did you subsequently have a conversation with either the defendant or her boyfriend?
Well, my neighbor knocked on the door and told me that Donna had been attacked by a dog. And when I got there, Donna was on the ground, and she comes running out with her phone saying, "This is my information," and they said it was all her fault. Well, when I come running out...
Just a second. Stop. Who came running out?
Nicole.
Came running out
Yes.
and gave you her information.
Well, she tried to, but I was more worried about my wife and my dog, and I'd just gotten up, so I didn't have anything to take any information down with me at that time.
Okay. Did you speak to her boyfriend?
Yes, he came by later on that evening and spoke to us.
He came to your house?
Yes.
What's your boyfriend's last name?
Tripp.
Mr. Tripp, would you stand up, please? I want you to be very careful what you tell me. You were there during this incident, and at some point, you got the pit bull off of one of the dogs. I want you to describe to me what you told Mr. Cullen that night, because that night would be freshest in your memory. This incident happened on October 12th, so certainly it would be fresher in your mind than it is today. So I want you to tell me what you told him the night of October 12th.
Your Honor, when I went over that night, I didn't tell him how I got the dog loose. As the dogs were fighting, I was yanking.
You were what?
As the dogs were fighting, I was yanking on the dog's leash for him to let go of the other dog. That's how I got him to let go.
Hold on a second. Well, that's interesting. Where did you get the leash from?
The dog was still on the leash.
There's a collar. The collar is attached to the leash. You were walking your basset hound. Where did you get the leash from, Mr. Tripp? Now you're starting to understand me.
From Miss Anderson.
From the ground.
From Miss Anderson, that's who.
No, you didn't.
Okay.
Sit down. No, you didn't. You know what happened? Mr. Tripp, just so that you know, Mr. Tripp, just so that you know what happens, sir, when you're asked a question and you're not prepared to answer it, Mr. Tripp, pay attention. When you watch this case, because you will watch this case, you will see that your artery popped out twice. You know why? Because you weren't telling me the truth. Now you can sit down. Now you're going to tell me your version of these events. Did you lose control of your dog?
No, I did not.
Did you have the leash in your hand at all times?
Yes, I did.
When did you hand the leash off to Mr. Tripp?
I'm not exactly sure how he got the leash out of my hand. I was trying to hold on to the dog
I'm
while
not
they
sure.
were fighting.
I'm not sure either. I'm not sure how he got control of the leash either. Got it?
Mm-hmm.
But certainly, two people weren't tugging on the dog at the same time. What did he tell you, Mr. Cullen, when he came over to your house that night?
He said that he was happy to see that she was going to go in the opposite direction that they were going. And the next thing he knew, that the dog had broken the leash and run away from Nicole. And by the time they got over there, he'd already checked on how to get a pit bull off of a person, dog, whatever, once it clamped down.
Is that what he told you?
Yes.
Mr. Cullen, I'm asking you what he told you. So he said to you he already checked on how to get a pit bull off somebody or something.
Yes.
This is what he told you.
Yes, he checked it out on the internet on how to do that. And
so he checked that out before?
Yes, he checked it out on the internet beforehand. And he said that you had to punch it in the back of the neck. He told me that he had to do it 3 times before the dog would release. And he's a pretty good-sized guy. So I don't know if I could have punched the dog 3 times and got it off or not.
Mm-hmm.
Judge Judy continues in a moment.
Has your dog ever bitten any animal before?
No.
Is there any reason why your boyfriend would have looked up on the internet that you can figure out how to get a pit bull off another living thing?
And later today,
You have a 5-year-old child, so it was the 3 of you living together.
Yes, Your Honor.
Did you have your own room?
No, I did not, Your Honor. We were actually...
Where did you sleep?
Donna Cullum says she and her terrier were injured when Nicole Anderson lost control of her pit bull.
Okay. Can I have the vet bills, please? Can I see the vet bills? And your wife's emergency care bill for her wrist that was bitten by her own dog that was your fault. Has your dog ever bitten any animal before?
No.
Miss Anderson, is there any reason why your boyfriend would have looked up on the internet that you can figure out how to get a pit bull off another living thing? Because there's no question he told that to Mr. Cullen. There's no question that that's what he told him, that he looked it up on the internet, how to get a pit bull off another living creature. There's no question that Mr. Cullen didn't make that up. Why do you think he would look up how to get a pit bull off a living creature? Because he has nothing else to do? Is he employed? Does he have work that keeps him busy?
Yes, he is employed.
I mean, I wouldn't look up how to get a Shih Tzu, which is what I have, off another living creature. I wouldn't look that up. Did you ever? Well, let me put it this way to you, Miss Anderson. He has a basset hound. Did you ever look up on the internet how to get a basset hound off another living creature? Did you ever have occasion to look that up?
No.
Just a second. Mr. Tripp, we're coming back to you. It's too much exercise. Did you ever look up how to get a basset hound off another living creature?
No.
Okay, can I see the bills, please? Okay. What was the entire vet bill?
$2,829.16.
And which emergency room or doctor did you go to?
I went to Mercy Southwest. It's a Dignity Health Hospital in Bakersfield.
And what did they do for you, for your wrist?
I had to have a tetanus shot because they gave me 4 sutures on the top and 3 sutures on the bottom of my wrist.
You own your own home, Miss Anderson, or does Mr. Tripp?
He owns the home.
I suggest, Mr. Tripp, that you advise your homeowner's insurance that you have a pit bull in your house. I assume you have homeowner's insurance. Mr. Tripp, who's the carrier of your homeowner's insurance?
Farmers.
Farmers. Do they know that a pit bull lives in your house?
Yes.
Do you pay extra for the pit bull?
Nope.
Unlikely. Judgment for the plaintiff in the amount of $5,000. We're finished. Thank you. We're done. Farmers, pay attention.
This case is concluded. Parties are excused.
I don't feel like it was my dog's fault.
It was entirely their fault.
Her dog actually nipped at my dog first, which caused him to then...
It was terrifying, honestly.
I worry about her every time she goes out and walks the dogs.
I'm glad her dog's going to be okay.
If I see a pit bull, I will go the other direction.
All parties in the matter of Blower versus Blower. Step to the podium, please.
Rocio Blower is suing her ex-husband, Drew Blower, for denting her car when he slammed himself onto the hood. Drew is countersuing for vandalism to his car.
Ms. Blower, this is what I gather from your case, from your sworn complaint. See if I understand why you want to get the courts involved in this drama with your ex-husband. You and Mr. Blower have a 5-year-old son together, and you are divorced.
Yes.
In what year were you divorced?
2016.
And then, according to you, in April of 2020, for whatever reason, the defendant moved back into your home.
Yes, he had just
and was
lost,
there April, May, June, July, August, September, 6 months, and this incident happened in October. Is that right, Mr. Blower?
Yes, Your Honor.
Now, Mr. Blower, I'm going to ask you a question. You have a 5-year-old child, so it was the 3 of you living together. Is that right?
Yes, Your Honor.
Since April? Did you have your own room?
No, I did not, Your Honor.
Judge Judy continues in a moment.
Our son again found his way on the top of Drew's car. Well, that must have been some good watching by his mother, and was using it as a slide. That's your sworn complaint. Courts don't help stupid people.
Real cases, real people. Judge Judy. Rocio Blower is suing her ex-husband, Drew Blower, for denting her car when he slammed himself onto the hood. Drew is countersuing for vandalism to his car.
Now, where did you sleep?
We actually all slept in the same bed, including our 5-year-old son. We only
Is that correct? Is that correct?
Yes, up until the last.
That's either a yes or a no.
Yes.
I don't care up until the last. April, May, June, July, August, September. This incident happened in October. Okay, so I'm going to give you the scenario that you laid out to me. His is different, and he's got to count, but you said that you knew that your former husband didn't like it when your 5-year-old son played slide on his car.
That's correct.
That's what you said, correct?
Yes.
And one day you were outside, and I assume you didn't let your 5-year-old son go outside alone because, as you say, he's a 5-year-old child and that your son is autistic. And so I assume you didn't let him out by yourself. And you say he likes to climb on Drew's car and use the windshield as a slide.
Yes.
And you say here that that irritates Drew. Now, the 5-year-old can't get to the hood of the car, to the top of the car, unless somebody puts him there. So you say, well, in October, while he was there and you were all sleeping in the same bed, our son again found his way on the top of Drew's car. Well, that must have been some good watching by his mother, and was using it as a slide. That's your sworn complaint. You say, I didn't want him to fall off, so I sat on the edge of the hood to catch him.
He would get at the very top of the roof. Yes, and he would tell me to sit.
That's what you said.
Yes. So I would sit on top of it, too.
Drew came out of the house and saw what was going on and became enraged. So he ran over to my car and jumped on it and slammed himself on the hood and left a dent. That's what you want him to pay for?
Yes, basically to pay
That's
for...
what your case is?
Yes.
No, that's what your case is. Yeah, forget it. You have a dent in the hood, live with it.
Judge Judy continues in a moment. Closed captioning sponsored by Butte. Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Okay, now you have a counterclaim because courts don't help stupid people. Children don't use a car as a sliding pond. Now, your counterclaim is that 3 weeks after, then she kicked you out of the house.
Yes, Your Honor.
Your counterclaim is that she wrote on your car, I need child support, thanks.
Yes, Your Honor.
Did you see her do that? Did you see that?
Physically? No, I have not,
Did you see her do it?
No, I did not physically see her do it.
And then you said she came to your place of employment and wrote something else on the hood dust of your car. Did you see her do that?
No, I did not, Your Honor. I was working currently at the time.
The counterclaim is dismissed. So then we're finished with this ridiculous case. Goodbye. Thank you.
Thank you.
This case is concluded. Parties are excused.
And on the next Judge Judy.
What I'm telling you is you took a car, as is.
The car does not run. This is a fraudulent sale.
Do you understand your problem?
No, I do not, Your Honor.
Next Judge Judy.
They both were out there on the car having fun. And, of course, you know, that would make anybody angry.
It's okay. I guess I can see the hood and just see.
Now we can move on from it.
He does owe $2,300 in child support.
Whether or not I do is not relevant to this case at the moment.
Of course, we can be better parents.
Want to be there for my son.
You owe him $3,950.
No, I don't.
The virus held up her security deposit.
I missed the walkthrough because I had COVID symptoms.
Your Honor, he didn't even let us know.
It's irrelevant to this case that you had COVID.
Now, a landlord holds nothing back.
You want me to go to a walkthrough and infect somebody with COVID?
Send your mother, send your father, send a friend. You're full of baloney.
This is Judge Judy. Michelle Spaulding is suing her former landlord, Kirk Wilterding, for the return of her security deposit.
Justice case number 113 on the calendar in the matter of Spaulding versus Wilterding. Parties have been sworn in.
Ms. Spaulding, your case is a relatively simple one. It is your claim that the defendant owes you your security deposit back. You and your family rented a house from him.
That is correct.
He gave you a 60-day notice. You did, in fact, move out, and he retained $3,950 of your security.
That is correct.
So far correct? Okay, so Ms. Spaulding's rented your house. They gave you in security deposit $3,950, which you know you're supposed to keep segregated in a separate account. Do you know that?
I do know that, and it was
That's
segregated.
a yes? Good. And you can prove that to me if I needed it.
Sure.
Sure.
Yes.
In what bank did you keep it segregated?
I have it in a separate account that's one of my LLCs, not a personal account.
What LLC do you have there?
Just my account.
$3,950.
My account. And I actually sent them a copy because they asked for it.
Then I'm just asking you, why can't you tell me what bank you have their $3,950 in?
It's Wells Fargo.
Okay, let's proceed a little further. According to you, you had a girlfriend, you were moving to California, you lived in your house for a couple of years, then you moved with your girlfriend, then COVID struck, and you decided you wanted to move home. They were already living in the house, you gave them a 60-day notice. That's what you wrote in your answer and swore to. Do you remember that?
Correct.
Good. And they did, in fact, move out. And you made a date to come with them as a result of your 60-day notice. You made a date to do a walkthrough with them before they left, which is what people do when they have a rental property, and you have an opportunity to look at and say, this is my damage, and I'm going to deduct that from your security deposit. You don't have to put anything anywhere. You weren't feeling well on the day of the walkthrough. That's what you wrote, correct?
Correct.
And according to you, you lost your sense of smell because you had COVID.
What does that have to do with the walkthrough?
Well, it has to do with the walkthrough, sir, because you say by the time you entered the house and regained your sense of smell, that's what it has to do with it. You said,
I didn't say
that
any
in your
of that.
answer.
You're just making that up. I didn't say any of that.
Okay.
I missed.
Really?
If you would like me to explain,
just a second.
I missed. If I can
No,
explain.
I'm just looking at it. I may, just a second. I may have been mistaken, so I'm going to read your answer. You said, due to COVID-19, I decided to move back into my house. I gave them a 60-day notice, and they complied. Michelle asked for her deposit back on the day they moved out. I told her she had to wait for damage checks, but you already had a date for a walkthrough that you didn't go to. I started feeling ill, so I missed their walkthrough. That's your sworn statement, sir. I have your signature on it.
It says nothing about smell.
Soon after that, I moved back into my house. I got COVID-19. Following my doctor's instructions, I quarantined until I felt better. That's what you wrote. When I finally got my sense of smell back, I knew I wasn't crazy. I can't make that up.
30 days later?
The smell of dog was obvious. The smell of dog was obvious, and I needed to change the carpet and pad. That's what you swore to in your answer, sir, right?
I missed the walkthrough because I had COVID symptoms. You can see I have a letter from my doctor, so I did not want to infect them. I didn't say that I didn't have smell.
I don't care.
And that's what...
No, just a second. You said...
30 days later.
You just said, I don't care, sir. You owe them $3,950.
No, I don't.
You missed the walkthrough.
There's more to the story. I missed the walkthrough because I was sick. I had COVID. So you want me to go to a walkthrough and infect somebody with COVID?
Send somebody in your place.
Your Honor, he didn't even let us know.
Send your girlfriend. So just a second.
I didn't have anybody available. It's a 2-hour drive. I have nobody available. I have nobody.
Send your mother.
No one.
Send
my
your
mother.
father.
My mother
Send
lives
a
in
friend.
Minnesota.
Hey, listen to me, sir. You're full of baloney because you lived in that house according to you
if you
for
would like
2
to,
years.
I came a long way. If you'd like to actually hear the story, and I have evidence, why don't you let me talk?
Listen to me. It's irrelevant to this case that you had COVID. It is totally irrelevant to this case.
Why do I wear a mask then? We're not supposed to infect people. We're supposed to. Nobody has to quarantine.
No. How many times have you had COVID?
No.
I've had it twice.
No. Shh. No. Listen to me, sir. Listen to me. Don't talk over me. I wouldn't suggest.
Well, you're not letting me talk. Why am I here?
Personally,
you're not letting me talk. Why am I here? Why am I here?
You're here to pay $3,950.
No, I'm not. This is ridiculous.
Judgment for the plaintiff. That's it. Out. We're done.
This case has been concluded. Parties are excused.
I'm honestly just happy that the truth came out. He clearly showed his true colors.
Because my whole house smells like dog. My brand new house, 2,800 square feet of carpet, smells like dog.
And that was my total interaction with him the entire time that we were his tenants.
They had it cleaned, they put perfume on the carpet, and it stinks.
Everything that comes out of his mouth is a lie.
So I have 2,800 square feet of dog carpet. It's $6,500 to fix, so their measly deposit doesn't even cover it.
I'm glad I'm done with this nightmare and I don't have to deal with him anymore.
All parties in the matter of Roberts versus Patton. Step to the podium.
Charles Roberts is suing Bryn Patton for the return or value of a dirt bike.
Mr. Patton, I'm going to start with you, sir. Mr. Roberts had a non-running dirt bike, and you own a mechanic shop, and he asked you sometime last year if you could get the bike up and running. I understand that Mr. Roberts, who I haven't spoken to yet, looks like a reasonably intelligent man. And you came out and you looked at the bike for the purposes of giving him an estimate as to how much it would cost to get this non-running dirt bike up and running. So far, am I correct?
Yes, Your Honor.
And you did, in fact, give him an estimate of what you thought, because you're the professional, of what you thought it would take to get the bike up and running, correct?
After we went through it, Your Honor, and diagnosed everything and did a complete workup on it.
No, at the house, before you took possession of the bike, he asked you for an estimate.
Which we cannot provide.
Did you give him?
No.
Well, what did you look at the bike at his house for?
Actually, we just went to pick it up to get it going for him.
Okay, great, great. So you went and picked it up. On what date did you pick it up? Do you recall, Mr. Patton?
I don't recall the exact date, no, ma'am.
Do you recall the month?
April or May of
Mr. Roberts, just give me the month that he picked up the bike.
It's unclear, and it's not documented. I believe it was March or April.
Say it was March in your papers.
That's my best recollection, Your Honor.
March of 2020. Okay, so you picked up the bike, Mr. Patton, according to you, and you just had an estimate of what it would cost to fix it. And you didn't keep that estimate to yourself because you're in business. So you relayed that estimate to Mr. Roberts. What did you tell him it would cost to fix the bike after you diagnosed it? No, I don't want to hear the word basically or like or about. Now you took the bike back to your shop.
We were given the instructions
I'm
to
finishing.
complete.
I'm giving you a question, sir. And what I suggest you do is a believable answer. If you don't, I assume you have family who are among the 9 or 10 million people who watch this program every day. I said to you at the beginning, Mr. Roberts is an intelligent person. If I took my bike or my car into a mechanic to be repaired, and they said I have to do a diagnostic, and they took the car to do a diagnostic, then they communicate with me as to what it will cost to fix it after they've done the diagnostic. So don't give me a lot of who shot John.
Judge Judy continues in a moment.
Now, I'm not believing you.
Okay. Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity. Sir, don't look slick to me, sir. I can tell slick. Don't think of what I'm saying to you.
The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
Tell me how that happened.
She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
Charles Roberts says mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
What I'm asking you, sir, is after the diagnostic, what estimate did you give them?
We were given an order to fix the bike and get it running so that it was in proper running condition. He was leaving town.
You know, I don't believe... Just a second.
Okay.
Now, I'm not believing you.
Okay.
Mr. Patton, I'm not believing you, sir.
Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity, sir. It belies credulity.
Well,
that somebody had a non-working dirt bike and said, as you're quoted in your answer, whatever it costs to fix it, fix it. So now, since I don't believe you, I'm going to ask you a couple of other questions, because that's what this case is about. He wants his bike back, and you have a ridiculous counterclaim. Now, for me, sir, I can tell slick. Don't think of what I'm saying to you. Is the bike currently running?
Yes, ma'am.
And is it currently in your shop?
Yes, ma'am.
Okay. Now, are you getting an appearance fee for coming to this program today?
Yes, ma'am.
How much?
To be honest, I do not recall. This is the third time this has happened, and each time things have been very different. So with the COVID, things have...
Fine. So you don't know. Whatever it is, you know it's something,
That's right.
Okay, good. So nothing better happened to this bike, because they're going to hold whatever that appearance fee is until we make this exchange and we have a running dirt bike. Do you understand?
Absolutely.
Great. Now, originally you say he came out and looked and said maybe between $300 and $400. Okay, that's a good guesstimate. You know, that never is what it is. You never get charged exactly the top end of an estimate.
Right.
What you say to me is, in your complaint, is that in July, so we had March, April, May, June, now in July, Brian texted me, which you have, that the cost of the repairs had increased and would be $580. Do you recall texting him that figure, sir?
I texted
Mr.
many
Patton.
times. Oh, wait.
No. At the bill, which originally you said would be maybe between 3 and 4, is now $580 in August. Do you recall saying that to him?
Yes.
Okay. We'll take a look at that text.
Here's the text. August 21st, he says $580 plus tax.
Plus tax on parts. So say the repairs was $600.
Fair enough.
Right? Say repairs was $600, but he said, I think I have a buyer. Forget any other deal. $600 with the repairs then. And according to Mr. Patton's answer, Mr. Patton, I want you to listen carefully. You said I had the bike fixed within a few weeks. So that $580 plus tax on parts was a completed figure. That's what the figure was. $600, which was twice the lowest estimate that I believe that you gave him, but a couple of $100 more than the highest estimate. And according to you, you said to him, I kept asking Charles to pick up his property and pay his bill. He kept making excuses. When I told him it would cost $1,500, he complained. Why would it cost $1,500?
Judge Judy continues in a moment. And later today,
I was being told that I'm not thankful for anything that he does.
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
real cases, real people. Judge Judy. Charles Roberts says mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
Now, why would it cost $1,500?
I don't recall why that I don't know how that conversation even occurred. I don't recall it.
You don't recall telling him that the cost was $1,500 now?
Charging him $1,500? I do not recall that. No, ma'am.
Did the person who wanted to buy the bike, because I'm looking at that text message, Mr. Patton, did the person who wanted to buy the bike, was that your son?
He's my son, yes.
Okay, and then he decided not to buy it.
Correct.
Did he use it?
No.
Did he ever ride it?
Yes.
How many times? Once or more than once?
During the
once or more than?
More than once.
More than 10 times?
No. And it's just not my
Between
son.
5 and 10
we have technicians that ride it.
Well, I'm talking just about your son, sir, not about the technicians, just your son.
Oh, no, he only rode it one time. The first time that he was going to ride it. He wanted to see if he was going to buy it or not.
Okay, very good. All right, it's a relatively easy case, Mr. Roberts. You see, you didn't have to say anything. You have to give him $600. When you give him $600 and go and retrieve your bike, you can do that with a marshal. The bike will be in perfect running order because that's what Mr. Patton says. It's in perfect running order, and there are things that we will hold hostage in order to make sure that you get that bike in good running order for the cost of $600, which you think is fair, correct?
Thank you, Your Honor.
Very good. Very good. We're finished. That's it.
Thank you.
Thank you.
This case is concluded. Parties are excused.
Well, I think it's a fair decision. It's a little frustrating because he quoted me $300 to $400 to repair the bike.
I believe it was a fair decision. I believe we kind of came here and got the answer we wanted.
Then the bill came back as $580, and then when I went to pick it up, he presented me with an invoice for over $1,000.
There was a dispute between the payment that he felt was owed and what we were charging.
I'm just like, this is a hostage situation. I'm not going to play that game.
All parties in the matter of Swenson versus Miller. Step to the podium, please.
Doug Swenson is suing his ex-girlfriend, Kathy Miller, for an unpaid loan.
Mr. Swenson,
Yep.
girlfriend for a couple of years.
Yes, ma'am.
From when to when?
It was March of 2017, I believe. up until September of 2020.
And it is your claim that just before the breakup, you loaned her $1,000.
Yes, ma'am.
You had a bad argument sometime in...
September 16th is when it was.
The answer says on October 18th, he showed up at my house unannounced about the money.
We could have the months.
But you broke up?
Yeah, it was in September.
In September, you broke up?
Yes, ma'am, on the 16th.
Okay. Did you go to her house to collect the money in October?
Yes, I did.
Okay. And you went to retrieve, according to you, the money she owed you?
Yes, ma'am. $500.
Hmm?
Yes, ma'am, the $500 that she owed me. That's why I went there.
Well, when did she give you any money towards the loan?
Okay.
I thought she gave you that money when you broke up.
Judge Judy continues in a moment. Closed captioning sponsored by Real Cases, Real People. Judge Judy. Have you been cheated? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Now, you went to retrieve, according to you, the money she owed you.
Yes, ma'am.
Give you any money towards the loan.
Okay.
I thought she gave you that money
when
you broke up.
I loaned her $1,000. The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
She gave it to you. Look, listen to me. She gave it to you voluntarily?
Yes, ma'am. She said exactly to me,
Tell me how that happened.
Yeah. Okay, well, now here's what happened. She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
We were arguing, and I was being told that I'm not thankful for anything that he does because he came and helped me find the car. He knows about cars. So that night...
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
I did.
Did you do that?
Because he was putting it in my face.
Well, that's not what you said here in your answer, which is the only reason I'm hearing this case, because you said he blocked my car in so I couldn't leave. I had no choice but to give him the money. But that's not what you just told me.
That was the next day.
What do you mean that was the next day?
The next morning he came to my house.
I want to know when it was that you gave him the $500.
When he came to my house.
Not at his. Make any difference. If you gave him the money, then you owe him the balance of $500, okay? And by giving him the $500, you acknowledge that you owed him $1,000, you gave him $500, you owe him $500. Oh, my God. Thank you very much.
Thank you.
This case is concluded. Parties are excused.
Thank you, Your Honor.
And on the next Judge Judy.
I think it was absolutely correct.
I guess it's fair.
I helped her out, and I felt she was very unappreciative.
Well, he gave me the money, and he said, don't worry about it.
We got in a huge fight. She wanted to leave my house in the middle of the night and stuff, and...
You know, don't take anything